Good day, everyone, and welcome to today's conversation on debate. Today, we'll be talking about redundancy and how it affects both employers and employees at large. On today's episode, I have two incredible speakers here with me, Benga and Aramide. They'll be shedding more light on the topic for today. And welcome to the very first edition on debate.
Thank you, Chioma, for having me.
So, how do you feel being on here?
Well, it was interesting. It's interesting. I feel good coming here because we are about to share knowledge. So, feel good. Mora.
How about you, Aramide?
Splendid. Very, very nice morning. Nice atmosphere to discuss some of these issues and that we'll be shedding light on. So yeah, thank you.
Okay, so we'll be going into why we're here for today. So I'll kick off with my first question. What exactly does redundancy mean in legal terms? Say that you're talking to let's say a non-lawyer, a layman. I for one am not a lawyer. So educate me. What is redundancy?
Well, redundancy, like the term implies, is not hard. If you know the meaning of the English word redundant, you are halfway there to knowing the meaning of redundancy. And what it simply means is that an employee is surplus to requirements. And as a result, the employer has to let him or her go. So when there is an excess of manpower in an organization and the employer wants to cut down on the number of employees, maybe because they are downsizing, they want to reduce the amount of the overhead costs, or there's a lot of they are shutting down operations. So you say that they are conducting a redundancy exercise. In that case, they need to let some employees go. So simply, redundancy occurs when an employer does not need an employee anymore.
Oh,
Okay. And just to, I don't mean to go all lawyer on you here, but then in the Labor Act, if you look at the Labor Act, the wordings used to define what redundancy is. You want to take note of two things. Redundancy is actually the permanent and involuntary loss of employment caused by an excess of manpower. Exactly. So you want to take note of those two things. It's involuntary. Neither party, especially not the employee. The employee is not voluntarily giving up their employment, but the employer has to make that decision for whatever reason, whether a restructuring or a recession or uncertainty, economic uncertainty. All of those are valid reasons for redundancy exercise.
so how is redundancy different from being fired or laid off for misconduct?
Do you want to take a stab at? Okay, so redundancy is different from being terminated for misconduct because redundancy attaches to the role, not the person. If you are laying a person off, the person has done something, maybe poor performance, the person has committed gross misconduct, and then you have to lay the person off or you have to dismiss the person. But in redundancy, you have maybe a business unit. You are letting go of that business unit because you cannot sustain that business unit, right? So that is redundancy. It is that operation or that role. Maybe, let me give you a practical example. In your organization, maybe you have like 3 receptionists and then you are cutting down on costs. You realize you have to let one person go because your costs your salary structure cannot now sustain having 3 receptionists. So you have to lay one of those receptionists off. So that is redundancy. But in termination, maybe for poor performance, you realize that out of those 3 receptionists, one is not performing his or her duty very well. Therefore, you need to let that specific person go as a result of his or her performance, of his or her conduct, right? It's not about the role itself, it's about the person. Which means that if you let the person go, you can take in another receptionist. But if you are doing redundancy, it cannot be heard that you let one person go today and in the next month you have employed another person. That means the role was not redundant to begin. Do you understand? So that's the difference between termination as a result of poor performance or misconduct and redundancy.
Okay, so in other words, redundancy has nothing to do with employees' performance.
No, it has nothing to do with employee performance. I think you are complaining, or if you have issues with an employee's performance, then you have to go through another route, not redundancy.
Oh, okay. All right, that makes sense. And that's, you've been able to take off that vague from my concept of redundancy. Yeah. So thank you very much. So moving forward, when is it legally acceptable for an employer to declare a role redundant?
There are different occasions that could give rise to redundancy. Just like I mentioned, in a case of economic uncertainty, a very, very relatable case in point that all of us know is the COVID. When COVID, the COVID pandemic broke out, a lot of companies had to let employees go, and the reason for that is not far-fetched, because of the fact that now everybody had to observe social distancing. There was loss of sales. Nobody's coming to the shop anymore. So businesses were struggling far and wide. And when you look at the books and your balance sheets, you're not able to sustain or justify the payments you're making to employees, especially when there is no work for them to do. They can't just be, just sitting in the office and collecting your money. So you have to come with a plan to let them go. And the courts actually recognize this. Every business, there are a plethora of cases to the effect that every business has the right to deem it fit to let employees go when they need to rearrange their books to ensure that there is sustained efficiency.
Oh, okay. All right, that's great. So how do you determine if a redundancy is genuine or just a cover for something else?
Well, the thing is, you have to be able to show by documented reason that these are the reasons you are letting these people go. You cannot just wake up one day and say you are letting a lot of people go. And let me add this here, that companies and business owners usually resort to redundancy when they have to let a lot of people go. Right. So they have to show defensible reasons that these are the reasons. They have to be maybe economic reasons, shutting down of operations, restructuring, all of those things that are legally recognized. It has to be recognized, it has to be provable before you can say you are letting a lot of people go. Right? So if I get your question again, how can you show that there are genuine reasons? It has to be documented.
So what is in a case where it's not documented?
Then you are going to have a lot of problems justifying your redundancy, a whole lot of problem in court, because you may be facing legal action for wrongful termination, right? And if you are not able to show cogent and compelling reasons why you are letting a lot of people go, then you are going to face a legal action in court. So the best way for an employer or a business owner or for management is for them to show reasons. You cannot just wake up one day and let many people go, right? You have to show that there are reasons. And if they are not able to justify those reasons, then your day awaits in police court.
And just to add to that, Bringer, of course, we advise clients looking to conduct redundancy exercises. And I remember one of the last clients, I think you were on that transaction. Yes, I was. One of the last clients, we advised him to actually document the rationale, right? So you want to, when you're negotiating, when you are telling people you are laying them up, you don't just do that with word of mouth. This is people's livelihoods you are talking about. So you have to be prepared. You better be prepared, right? So one of the documents you should be looking to present is probably a memorandum of the rationale for redundancy, whether it's a restructuring, whatever the reason. Yeah. You also want to show them the organogram, which is basically
What's that?
the organogram is the hierarchy. It diagrams a representation overview of the hierarchy in your work organization. You want to show them the organogram of the workplace before the redundancy and after the redundancy. You want to, the essence of this is you want to show your staff that, okay, this is why we are making this decision. And after you will be let go, this is how we can ensure sustained efficiency as an organization. You also want to show them any evidence or maybe elimination of the roles or consolidation of the roles. All of that should be documented. And once you have it in written form, you can make a more compelling case. And of course, it serves as a defensible paper trail for you in court. Should you be facing actually court.
Okay, all right. Moving on, what rights does an employee have when they are declared redundant?
Well, rights. To be very honest, when you are declared redundant and the employer has followed the laid down procedure, I do not think, I don't want to speak categorically now, but if you are declared redundant, the reasons are provable, they are defensible, they are documented, and the procedure laid down by the law were followed. I do not really think that the employer has any right except redundancy payments. Now,
Can you explain that?
okay, so under the Labor Act, which is a law governing relations between employer and employee in Nigeria, when you want to conduct a redundancy exercise, you have to follow 3 procedures. Number 1, which I call the CAN, so that people can remember. Consult the trade union of the person, of the employer, of the employee or employees, or the workers' representatives of the employee or the employee.
Okay.
2, apply the principle of last in, first out. I'll explain that later, but our present purpose is to explain redundancy payments. Now, the third one is to negotiate redundancy payments with the redundant employee. So, the redundancy payment is, look, we are letting you go. We want to take away your livelihood, right? You need something to fall back on. So, those are the rights that you have, and it has to be negotiation, right? It cannot be take it or leave it. The employer cannot say, okay, this is the amount I'm paying for your redundancy payment. If you don't want, then you're on your own. No. You have to negotiate between, most times, I've been in meetings where redundancy payments were being negotiated. Most times it's usually between the employees that have been let go, the representatives of the employees, and the employer. So there has to be a roundtable meeting in negotiation. Okay, this is how much we are collecting. This is what will be in the redundancy package. So that is the right that the employee has. If all of those procedures are followed, then the mob will help.
So and just to add to that, I think the standard that the law holds the employer to in such an instance is best endeavor. Yeah, they must use their best endeavor when negotiating. Which means, like you said, no take it or leave it. You must be seen to have explored all the means to make sure that your employee is well settled, fairly settled, having recourse to your own financial and operational reality at that point in time.
Okay. You had mentioned something earlier, Benga, about the redundant employee being in an association, right? So you didn't really go in depth on that. But what if they're actually not identified with an association.
Then the employee will have to be the one to negotiate directly with the employer, and the employer will have to tell the employee the reasons for him need redundancy. There has to be notice, right? The law does not really make these provisions, but under fair legal practices, if the employee does not have a trade union, does not have a workers representative, it does not belong to a trade union or a workers union, then you have to make known to the employee that you are letting them go because of so and so reasons. So, but if the employee has a trade union or a workers representative, then you have to consult with them. But so,
yeah, and usually some contract. Now back to your initial question as regards what rights accrue to an employee in a redundancy event. Usually some employment contracts contain clauses on redundancy. Say, okay, if we are to make you redundant, we pay you.
yeah, these are what we're going to say. Exactly.
When you have to let that person go, you have to honor the term as contained in the contract about how much you are going to pay the employee in
What if as an employer you don't have up to that?
Yeah, that's why negotiation.
Okay, that's when negotiation comes.
Yeah.
Oh,
Actually, it's a negotiation. It's not something that is fixed in stone. I want to pay this, or I accept this. Okay, maybe let's make a compromise.
oh, okay.
Yes.
So if it's clearly stated in the employment contract, then the employer has to pay
Exactly.
the employee. Oh,
All agreement must be honored. So if you put something down in an agreement and parties execute the agreement, then you have to honor that agreement. So if you put, I'm paying you 5 million as redundancy payment, I'm paying you this and that, I'll settle this and that, you have to honor it
oh, okay.
when you are making your redundancy payments.
All right. So can an employee challenge or dispute a redundancy decision? Can he challenge or dispute a redundancy decision?
If you have a ground to challenge the redundancy decision, then absolutely you got support. And obviously the very immediate reason that will come to mind is where you don't follow the process. Section 20 of the Labor Act already outlines all of the steps you have to take. The can, you're right. So you consult, you apply, then you apply the LIFO principle, and of course, shift. If you skip any of those steps, you have a ground to challenge a decision. If you treat certain employees in the redundancy exercise different, let's say I'm laying multiple staff off. Let's say I'm laying Benga and Shema off now. I don't pay because Shema is my person. They'll say, Shema, I'll pay you 1 million. What Benga I pay you 500,000, 500,000 within month. You can see that there is unequal treatment. And of course, that's a ground for Benga to now say, okay, I'm taking this up and I'm bringing an action. Also, if following the redundancy exercise, you find out that, okay, they laid us off. Let's say, for instance, I'm an HR in a firm, and okay, I've been laid off, and then only for you to find out the next week that you're carrying for that, then of course you have a ground to challenge the decisions. So yeah, those are some of the grounds that will give rise to challenging a redundancy decision.
Let me add to that. Another ground that a worker can also have to challenge a redundancy exercise is when there's actually a redundancy, but the employer does not want to pay redundancy payments and then went through the route of termination. Because termination is, I would say, maybe more friendly to the pockets of an employer. It's less expensive. So you just have to give.
expensive.
Yeah, because I just pay you in lieu. Let's say 1 month notice and 1 month notice you and you salary you or something. So which generally is mostly just 1 month salary. As opposed to your redundancy where they'll pay you 6 months work or even 1 year.
Oh wow.
Right. So because employers do not want to go through that process of redundancy, and because the procedure is rigorous, they like to hide under the fact that they are just terminating this employee. But the court have said in plethora of cases, it doesn't matter what you call your retrenchment exercise. It is the fact and circumstances of the case that matter. So if it is a redundancy exercise and you call it termination, you call it dismissal, it doesn't matter. The court will characterize it how it should be characterized, right? So if it's a redundancy, then it is redundancy. So employers will usually want to escape the demands of Section 20 of the Labor Act by doing termination. So you can challenge the redundancy exercise on that ground that, this is not termination, but it's actually redundancy. And I'm entitled to so, and so under my contract of employment, or as the case may be, you have a fallback to the provisions of Section 20 of the Labor Act.
All right. So what's your advice to employers when they're about to make a redundancy policy?
So, you want to start with your documentation. You want to make sure all of the documents you need are intact, so that you have the defensible paper trail for all of the representations that you're making to employees. You also want to make sure you're consulting with the right people. It could be the workers' representatives or the trade union. Any agreements you reach with them, any negotiations you reach with them should also be documented and should form part of whatever severance that you are giving to these employees. Then I think that should be about that, documentation, basically. Documentation, and of course consulting with the necessary stakeholders to make sure that you have a very transparent and amicable redundancy.
Okay. Benga, do you have anything to say?
Yeah, that's what I said. Reiterate what Aramide has said and what I've said before. For HR managers, for employers, business owners, remember, can is your point. Consult, apply, and negotiate. Those are the 3 steps in the procedure laid down by the law. And you have to follow that procedure to the letter in order not to expose yourself to legal action. So you have to be procedurally rigorous. Consult with the trade union in anticipation of the redundancy exercise. I must emphasize that it is in anticipation of the redundancy exercise. You don't lay employees off this month, and that is the same month you are consulting the trade union or the workers' representative. You have to have done it. You have to have done the consultation before you embark on the redundancy exercise.
Oh, okay.
Yes, and apply the lasting post-out principle. Lasting post-out principle is that the person you employed last will be the person you will let go of first when you are doing a redundancy exercise. Although the law has qualified that lasting post-out principle to me, that to say that if a particular employee that came in last is very useful for your business, very valuable, he or she has very valuable skill, he or she is very capable, you may deviate a little from the lasting post-out principle, but it has to be proven that this is the reason why you are deviating from the lasting post-out principle. Otherwise, you have to apply that principle, which means that the most senior persons will be the last persons to be laid off when you are conducting your redundancy exercise. And then you have to use your best efforts to negotiate redundancy payment. So those are the laid down procedure. Those are the procedure laid down by the law. Now, practically, HR, they need to work hand in hand with their legal advisors or their legal department. You have to carry the legal department. You have to carry them. You have to inform them about what is happening every step of the way. You don't do, because we have been in a situation where, business owners or HR managers would have laid employees off, and then they will come back to legal and say, oh, can you render a legal opinion on whether? No, they are putting the cart before the horse. So you have to carry them along. You have to carry the legal department along every step of the way so that you don't expose yourself, so that you maintain procedural rigor. So that is my advice to employers, business owners, and HR managers. I want to re-emphasize that Khan is your friend. If you're an HR, a business owner, or you are a manager in an organization and you are in a situation where you have to conduct a redundancy exercise.
So there you have it. You've heard from Benga and Aramide, and I hope you learned something new about redundancy. Hope to see you on the next episode. And don't forget to like, share, comment, and subscribe.